Hello everyone, welcome back to my channel Study with Neha Mawa. So today I am back with another video, but before that I welcome you all those who are watching my video and finding it very helpful. So without wasting time, let's get started. So, in today's video, I'm going to tell you about the commencement of proceedings before magistrate. This is a new topic that I have come across, and this is a new topic that we're gonna go through it, and I'm gonna teach you about the commencement of proceeding before magistrate. So, let's get started. Firstly, when we are talking about the commencement of proceedings before magistrate, we should know against whom or in front of whom we have to start this proceedings. First of all, when we are saying that commencement of proceeding before magistrate, it covers under means in this topic we gonna cover at least six sections under this. We have to start with section 204 till 2010. So in firstly we have section 204 that talks about the issue of process. Issue of process means the starting of the proceedings from where your proceedings will start. Whatever the issue you have, the starting of the investigation, the starting of the proceedings in the court of session, there we have the starting point under section 204. So section 204 states that if in the opinion of a magistrate taking cognizance of an offence, there is sufficient ground for proceedings available and the case appears to be a summon case or a warrant case. So firstly, when the any issue or a matter comes in front of the magistrate make it sure that the facts under it are relevant or they are the fiduciary one or they are the self-made one. Then in the issue of process, firstly we have to start with the proceedings. The magistrate will start with the proceedings in which the person who went to the court to make that proceeding start, the person has to pay the process fee. Then only the proceeding can be started further. Now the magic in this case, when we all know, like the first of all, the the FIR is lodged. When I will talk about the very recent one, firstly the FIR is lodged by the informant, then the arrest is done, then the arrested person has to be in front of the magistrate within 24 hours of the arrest. These are the starting point or the starting level of the proceeding by which the matter may get transferred to the magistrate. So here we have the commencement of proceeding before magistrate means now it is fully responsibility of magistrate to go further with it. Now the work of the police officer is very much less as compared in the your FIR or in the arrest one. Now in this, in order to proceed with the the recent case, the magistrate can issue the summon or the warrant. In summon, he must issue summon for the attendance of the accused. Now please make it sure that in summon case only summon is issued, no warrant is issued, but in the warrant case summon and warrant both can be issued, not at the same time but at the different time depending upon the nature of the case. Here the summon case, in which why the magistrate issues summon to the person in order of the or for the personal attendance of the accused. When the magistrate find it very important that the accused needs to be present in the court, then the summon is issued. But a warrant cases, if he thinks fit, then he may issue a warrant or a summon for causing the accused to be brought to appear at a certain time before such magistrate, some other magistrate having jurisdiction in other matter. Now what happens is, for example, being a magistrate, I send a summon to a person. The person didn't came on time, he didn't obeyed my rules, or he didn't obeyed my the due means the order I gave to that person to appear in the court. Then I will issue a warrant. Now summon is just the attendance of the accused, but when warrant is issued, when the person does not fulfill the order of the summon, I gave the order to the accused to get present in the court, he dismissed my order, he didn't obey my order, so I will issue a warrant. Firstly, the summon is issued when the person or the accused does not obey the summon one, then the magistrate has to issue the warrant. Then next we have section 205, that is magistrate may dispense with the personal attendance of accused. As I told you, the magistrate sent the summon to the accused to get present in front of the magistrate, to get present in the court whenever called upon. So section 205, which contains a rule of procedure, provides that whenever a magistrate issue a summon, he may dispense with the personal attendance of the accused and allow him to appear through his pleader if there is sufficient reason for doing so. Now the magistrate just need to ask some question or to get the information. That's why the summon is issued. That's why the personal attendance of the accused is required. So it will be seen that this section deals with the exemption from the initial appearance, not with the exemption from the appearance. You, if you are exempting from the appearance in the court, you may have some reasons, but those reasons should be valid one. Now this power can be exercised by magistrate only when the summon has been issued, but not when the warrant is issued. Now you have to understand that under which whose jurisdiction, means who, which magistrate, okay, will send summon and will do all these things. It is the magistrate of the first class only in the court of session. Then okay, so personal attendance of accused is very much important whenever called by the magistrate. Okay, so being, for example, I being a magistrate, so magistrate firstly issue a summon to the accused to get present in front of the court. If the accused disobeys the order of the magistrate, which is sent from the court, then the magistrate will issue a warrant. Then in the warrant, you have no excuse to give that you were not present by this and that. So if, even though if you are not present in the court whenever you are called upon in the court, you must have the valid reason for that. If you don't have valid reason for that, if you are making by your own, then the magistrate may issue a warrant, and then magistrate may take strict action against that accused. Now another section we have, before this we have one case, Dinesan versus KV Baby 1981 case. It was held by the court that the provision 205 of CRPC provide that an accused may be present by his pleader if magistrate allows so, and if for that interest of justice it is required that accused shall be present, then magistrate direct accused to appear before him. Now magistrate is not applying here hard and fast rule for the accused to get present in front of the court. Just magistrate wants to know something from that accused. We cannot say that if you will not if you will if you will come in front of the magistrate, then he will scold you or he will send you behind the bars. No, but there is a very smooth procedure of it. Okay, so it is said that if you are present, if you are getting present in the court along with your pleader, it is not a wrong thing. You can do it. Okay, but you have to obey the rules of the, you have to obey the orders of the magistrate or the court. Then we have section 206, that is special summon in case of petty offences. We all know that offences are of two kinds, petty offences and the serious offences. In serious offences, we know either the summon is issued or either the warrant is issued. But in section 206, we say that special summon in case of petty offences. Now in the petty offences, generally magistrates do not call upon the accused in front in the court. There is no personal attendance of the accused, there is no personal appearance of the accused in the court, but court says that if a person has done petty offenses, then the person can send the fee, can send the fine along with a written statement through the post. It is section 2206 of the code of CRPC that provides an abridged procedure for disposal of the petty offences. Now, how the petty offences is being disposed of? As I told you earlier also, the petty offences are disposed of with the fine not exceeding 1000. For example, I being the accused, I have done some petty offense. I am not that much of it is not that much of serious nature that I have to be, present in front of the magistrate. No, just what I have to do is I have to just pay the fine of 1000 rupees along with a written statement that I will not do this offense again in my life. This is a written statement along with the fine, and I will send it through the I will send it through post. Then petty offense means any offense punishable only with the fine not exceeding 1000, but any offense so punishable under the Motor Vehicle Act 1939 or any other law. Exceptions are always there. The accused person in his absence on a plea of guilty is not included. Then we have section 207, that is supply to accused a copy of police report and other document. It is very, very, very much important for the accused to get the copy of police report and the other document that are against him or her. This section provides that accused should be given relevant document or extract of them in case where the proceedings have been instituted on a police report, so that accused is liable to know the charge brought against him and the materials with the aid of which the charge is going to be substantiated by the prosecution. Now, whatever the charges are framed against the accused, it is the right of the accused to know about those charges which has been imposed on him, and he should get the police report. He should get the copy of police report and the other document, the copy of police report, the copy of complaint, FIR, even the evidence which is instituted against him. Each and everything must be supplied to the accused, and that should be free of cost. There is no fee against it. Now, non-supply of material mentioned in section 207 which are relied upon the prosecution is a ground that can be used successfully for setting aside a conviction. Supply of the relevant. Now, what they are saying is non-supply of material mentioned in 207 which are relied upon prosecution as a ground of the means, for example, the victim or the respondent is saying that I will not give any kind of documents to the accused. Now, this is a point of the conviction of accused from that whole case. Okay, the supply of the relevant copies of the document and statement to the accused. There is another case here, State versus Ranbir Singh 1965 case. Then we have section 208, that is supply of copies of statement and document to accused in other cases triable by the court of session. We all know generally the cases are being tried by the court of session under the magistrate of first class. So in the cases instituted otherwise than on a police report, copies of documents specified in subclause 1 to 3 of section this statements recorded under section 200 and 202 statement. And now what are the document we need to deliver it to the accused? First is a statement recorded under section 20 and 200 and 202. Statement and confession, if any, recorded under section 164. Document produced before the magistrate and on which reliance is placed by the prosecution. Each and everything must be delivered to the accused, otherwise the conviction of the accused will get cancelled. Now, it has to be furnished to the accused only if the offence is triable exclusively by the court of session. The only exception made under this section is in the favor of the document which are voluminous, in which case the accused will be permitted to inspect them either personally or through the counsel. Now we have section 209, commitment of cases to court of session when offence is triable exclusively by it. It has been stated in section 209 that in a case which is instituted on a police report, otherwise if it appears to magistrate that offence is triable exclusively by court of session, the magistrate must, after complying with section 207 and 208, he should commit the case to court of session and meanwhile remand the accused to custody, subject of course to provision of the code. Now, why the accused is sent to the custody? In order that the person the accused may not tamper the evidence, may not do something wrong with the evidence, may not get flew away, or may not get uh, be in any other case, means should not hinder any kind of the judicial process. So remand of the accused to custody during and until the conclusion of the trial according to provisions of court relating to bail, means when the uh, case is being tried in the court of session, means the person should be in the remand, should be in the custody until and unless the final conclusion is in front of the both parties. So if there are any record of cases and the documents and article which are to be produced in evidence, then such record are sent to the court. Okay, there should be a valid reason for it. Then the last we have section 2010, that is procedure to be followed when there is complaint case and police investigation in respect of the same offences. Now, where a complaint case is pending before a magistrate and he has information that an investigation is pending before the police in relation to the very same offense which is subject matter of complaint case before him, the inquiry or trial whichever may be pending before the magistrate shall be stayed and a report called for from the police, means procedure to be followed when there is a complaint case and the police investigation in respect of the same offense. Now the magistrate should take into consideration that case and should try to do that case a justice, and the magistrate should give judgment as soon as possible in order to make that case a good one, make that case a real one, because as we know that justice delayed is justice denied. So we should not, or the magistrate should look into the matter and should not focus that justice should delay. No, justice should not delay, because otherwise it will be equivalent to justice denied. There was another case, Joseph versus Joseph, 1982 case. This is all. This is not a very big chapter. This is a very little chapter. So it is just in this the commencement of proceeding before magistrate. In this chapter we have only 6 sections that we have to consider, so this is not a very big one. Just whatever I explained in this video, that is much more enough for you to understand this, because in exam you will not get a 15-mark question in this, it will be in a 5 marks question. Okay, so if you like my video, please do subscribe to my channel, share with your friends and like my video. Thank you and have a nice day.